Good afternoon. I'd like to welcome everyone to today's webinar, the EB5 program reauthorized, understanding the new legislation, presented by our guest panelists, who we are extremely grateful to have with us today, Mr. Robert Devine and Mr. Robert Kraft. Robert Devine leads Baker Donelson's Global Immigration Group, specializing in EB5, concentrating his practice in business immigration and litigation. Mr. Devine served as Chief Counsel of USCIS, the world's largest immigration services agency within the U.S. Department of Homeland Security. He also served as Acting Director and Acting Deputy Director. Mr. Devine has also authored Immigration Practice, a recognized comprehensive guide to U.S. immigration law. He's often called upon to testify before Congress on immigration matters and is trusted by policymakers for his expertise. Mr. Devine also served as Vice President of the Board of Directors for IIUSA, the National Trade Association, for the EB5 Regional Center Program for 7 years. He joins Bob Kraft on today's webinar. Mr. Kraft serves as First Pathway Partners Chairman, President, and CEO. Mr. Kraft is Acting President of IIUSA's Board of Directors, where he has been reelected for his fifth consecutive term of service. His leadership of IIUSA has led the EB5 Regional Center Program to bipartisan, bicameral legislation, a historic first in its reform and long-term reauthorization. Mr. Kraft has worked diligently through advocacy efforts among his extensive congressional network, publication in the media, and furthering the public education of the EB5 program's contributions to the U.S. economy. He provides ongoing support to the EB5 industry-related organizations, presenting globally as an expert resource on media platforms around the world. Mr. Kraft's deeply rooted knowledge and experience, paired with his personal investment in this field, make him a driving force in the industry's continued advancement and success. Before we get to the open discussion with Mr. Kraft and Mr. Devine, please make note of the following disclaimer. The information provided in this webinar does not and is not intended to constitute legal advice. Instead, the presented analysis is for general informational purposes only. Please contact your attorney to obtain advice with respect to your personal case. Throughout this webinar, you will have the ability to submit questions in the Q&A box located at the bottom of your screen, and we will answer those for you live. This webinar is also going to be available on demand to registrants and loaded to our YouTube channel. And we intend to also host a podcast with Mr. Kraft afterwards as well. With that, I'm going to let Jennifer Scher, Senior VP of FPP, take over and moderate the forum for the rest of today's webinar.
Thank you, Jessica. So first off, I'd like to congratulate everyone on the reauthorization of the EB5 Immigrant Investor Regional Center Program. This should be a very interesting conversation, given how close both of you two gentlemen were in the process. Robert, for instance, I know you played a huge role in providing commentary and technical edits on the draft text and many iterations of the bill. And Bob, through your role as IIUSA President, I know you've spent probably more time than I can get you to admit on advocacy for the protection of investors who are in the process now, and then also for the future stability of the program. This legislation has been in the making for, what I would argue to be the better part of the past decade. I can remember as far back as 2012 already having, some of these same conversations. So it's very exciting to finally put an exclamation point on the sentence. But before that, Bob, can you start off by giving us a little bit of history? Prior to 2015, we routinely had long-term reauthorizations. What happened and how did we get to where we are today?
Yeah, thanks, Jennifer. And Robert, good to see you. And thank you for everything you did. You were very critical in moving this legislation forward. And I know you put a tremendous amount of time and effort into providing guidance and drafting and edits. And, words, aren't adequate to thank you. But it's good to see you.
Thank you.
It's been a long battle for the industry, for IIUSA, And there have been a lot of different start, stop over the years. Everybody's familiar with the history with respect to 1 year authorizations, couple month authorizations. I mean, it's just been tough for everybody. Through that all, IIUSA has stood steadfast with respect to the need to protect the investor. We have supported and continue to support, and are very appreciative of the efforts of Senator Grassley and Senator Leahy. Their whole vision was to reform the program to, number one, protect the investor, and to bring the program more in line with the original intent of Congress when the bill was passed in 1990 and then modified with the Regional Center pilot program in 92. And that intent was to provide opportunity for investors from around the world to think like entrepreneurs, to invest in American job creating entities that, if not for EB5, might not be able to put into place. The intent was to drive economic development in rural areas and in targeted employment areas. I mean, over the years, the program, because of some of the ways it was interpreted, kind of changed dramatically in terms of that original intent. This new authorization is designed to protect the investor first, and we stood steadfast with Senator Grassley and Senator Leahy to make sure that we had a program that, number one, protected the investor. Integrity reforms are critically important. That's a big part of this program. The good operators in the business supported this because they were operating in that spirit all the way along. It'll eliminate some of the abuses that were in place and took place in the past, and it'll tighten the program down and bring it in alliance or have it comport with the original intent. So, it's been a tough battle. We've taken, as an organization, a lot of criticism. Some people have even said we wanted to kill the program. That's the farthest thing from the truth. We hung in tough and believed in protecting the investor first, and now we're in a good place. Certainly, there'll be some sorting out with respect to some of the text and some of the new requirements, but it's a very, very good bill, and it will achieve stability for the industry with a 5-year authorization, and, number one, protect the investors, which really is important for the whole industry, and we'll get going again here. So I'm very, very pleased with a concerted effort from people across the country and the support of Congress. This was bipartisan support, bicameral support, and it's a really, really big win for the investor and the future investors and for the industry.
Yeah, it really is a huge win, I think, for investors all around. Robert, one of the things that I'm most excited about in this bill, and then, sorry, we also have Robert and Bob, so I'll just address you by Robert and Bob.
Okay.
And keep from getting confused when I say Robert and you both look. So one of the things that I'm most excited about in this bill is concurrent adjustment of status. And I know a lot of the investors are very excited about that too. Let's start off really simple for, there might be some new investors that are in the audience too as well. What is an adjustment of status and who currently qualifies for that?
Okay, so adjustment of status is if you're already in the United States when your I-526, well, when you're eligible. If you're in the United States, when you become eligible, and we'll get it into what makes you eligible, then you can apply to get your green card by staying in the United States and just applying to switch your status from the temporary status you have to becoming a permanent resident. The other older original way is instead to apply for an immigrant visa at a U.S. consulate outside the United States. So those are the two ways. But if you happen to be here in the United States when you become eligible, then you can just apply here and you don't have to leave. You do have to apply for interim travel and work authorization, and you can't leave the United States while you're waiting for that travel authorization, except in very rare circumstances. So some people choose not to do it. They choose instead to just process for an immigrant visa at a foreign consulate. But if you are here in some way that might expire before too long, and you can go ahead and apply for adjustment of status to permanent residence, then that could really help you be able to just stay here for what might be some years while the process gets adjudicated. So what happened in this law, well, in the past, EB5 investors could only apply for adjustment of status if they had an approved I-526, which is the first step in the EB5 process. But this law says if you're here and otherwise kind of in good standing, when you file the I-526 for EB5, then you can concurrently, at the same time, you can apply to adjust your status within the United States. So that could mean years of extra time being in the United States while you're waiting for your I-526 to become approved. It's a huge deal. Now, big question is, who can do that? Is it only new investors who file their I-526 after the enactment of this law, which was yesterday? Yesterday, the president signed this law that the EB5 bill was part of, and that's the date of enactment. So would it only be new filers, or would it be people who already had filed their I-526? Maybe it's still pending. But if they happen to be here on a student visa or some work visa, or even as a visitor already, now that this law has passed, could they file for adjustment of status, even though they don't have an approved I-526? I believe that that law is immediately effective even as to them. So I think everybody can take advantage of this law. If an I-526 has already been filed for you and you're here and otherwise eligible for adjustment, then you can file. The other thing that this law did is a little bit technical, but it's very helpful, is it included EB5 investors in something that otherwise employment-based immigrants already could use, and that is a certain amount of forgiveness. It used to be, without this being included in this forgiveness law, you have to have had a perfect lifetime immigration record in order to apply for adjustment of status within the US instead of going home to apply for a visa. And that meant if you had overstayed your status for one day in previous years, you wouldn't be eligible to apply for adjustment of status. But this now, EB5 investors can apply for adjustment if, since they last entered as on a visa, they can, if they have overstayed somehow for up to 180 days, or maybe they worked without authorization for up to 180 days, they still can be eligible for adjustment of status. And if they had an overstay in the past that wasn't too long, it still would be forgiven. So it really expands who could apply for adjustment of status, even for people who have an approved I-526, but especially for people who have only filed it.
That's really exciting, just knowing that both for new investors who are entering into the process, they can file their I-526 and then file their their I-526 and their I-485 at the exact same time. And then for existing investors too as well, the ability to, if you have your I-526 pending, to be able to also file for I-485. I mean, that can cut a bunch of time off. I mean, right now, we're seeing adjustments take upwards of a year. So if you can cut an entire year off of your process, I think you're sitting in pretty good shape. there's also been a little bit of back and forth, and I've heard several different positions on the next 60 days. During the next 60 days, those people who have I-526s pending right now, do they have to wait for the 60 days to be up to file their I-485? Or do you think they can start filing those I-485s right now?
I think they can file them now. I don't see any reason not to try. I mean, I can't guarantee that USCIS will agree with me, but I don't see why you couldn't. The old law, the old regional center law has been repealed by yesterday's enactment. But that law also says anybody who filed before enactment can be adjudicated nevertheless, and under the rules that were in effect when they filed. So they're not subject to any retroactive new rules that could make them ineligible. So given that, and the fact that the law that says people can concurrently file for adjustment just refers to anybody who qualifies under EB5, I think it applies to everybody.
So the worst thing that can happen is they send it back to you, right?
Yeah, without cashing your check. So what's the risk?
Okay, great. Now, also, there are a ton of priority dates that are current right now. We've got India and Vietnam, which usually aren't current, and they are both current right now on the visa bulletin. And the annotation below in the most recent visa bulletin also says that that they're expected to remain current once the program is reauthorized, which is now. So for those folks, they can file their I-485s right now too as well.
So if somebody, you're talking about if somebody is already here in a non-immigrant status, temporary visa status, and they have previously filed an I-526, can they file for adjustment of status? Is that what you're asking?
Yeah, if they're from a backlogged country.
Well,
Previously backlogged.
The way you normally do that is you look at the visa bulletin and see if the visa number is currently available. The visa bulletin that's currently in effect for March of 2022 says that that non-regional center investors are unavailable, right? That's what it says for March. Because until this law was enacted, they were unavailable. That's going to have to be amended. And I noticed that today, I don't know when it came out, I see it today, the April bulletin. So the State Department publishes a bulletin for April that that people could use when they file in April, that shows everybody but China being current. So there's a meaningful possibility that nobody's going to be able to actually file. I'm glad you brought this up. It's a meaningful possibility that nobody would be able to apply for adjustment of status who's a pre-enactment filer until the State Department revises the March visa bulletin. Otherwise, USCIS could reject the filing on the basis that, hey, the visa bulletin says unavailable. I mean, it shouldn't say unavailable. The State Department should be changing this any second for the March visa bulletin. And they said so in the March visa bulletin. I'm sorry, I'm bouncing back and forth between those two documents. But they said that we're going to have to revise this once the law gets enacted. And they didn't, at the time they wrote that, they didn't know what the new law was going to say. At the time they published the March visa bulletin back in February, they had no real clue what the final EB5 bill was going to say, and nobody knew for sure. So I think there's going to have to be an amendment, And I believe that amendment will reinstate a priority date for China. You can see from the April bulletin that they just published that it says December 15, 2015 as the cutoff date, and and every other country is current. So I think that's what they're going to revise it to as soon as they revise the March visa bulletin. I don't think they'll wait till April and just leave it as having published the April bulletin and everybody has to wait till April, but they might. If you want to file today, you're kind of taking a chance that USCIS might reject it because of the visa bulletin saying unavailable. But they might accept it because they know it's not really unavailable. It shouldn't be.
Right.
Sorry, that's kind of complicated.
Yeah, Department of State has had a history of putting those little notes down in the bottom note section too as well, that just say, you know, once visas do, or once the program is reauthorized, that they will make visas available.
Well, they did say if there's legislative action extending this category for March, the final action dates would immediately become current for March for all countries except China mainland born, which would be subject to November 22, 2015 final action date. Well, they haven't done that yet. They said they will immediately do that. They haven't done it yet, but you know, the wheels of government don't always turn instantly. And you know, somebody other than from China could file, or even from China who had a priority date before November 22, 2015, could file for adjustment today and hope it might be accepted, you know, highlighting this language in the visa bulletin that they could include in their filing and highlight it in their attorney's cover letter. It might work, might not. But you know, if they reject it, they said they don't cast the check. So
so next, let's say you file your I-45, you are eligible, and then later, subsequently, your category retrogresses. Now, I know that this change for concurrent filing puts us kind of on par with a lot of other different categories that also have concurrent adjustment of status. You know, how is that handled in other categories when that category then retrogresses after you filed your I-485?
Normally, if on the day that you file your application for adjustment, a visa number is available. And then after that, for whatever reason, the State Department revises the visa bulletin and posts a cutoff date that is earlier than your I-526 filing date, then USCIS doesn't up and deny your application. Instead, they hold it in abeyance and they continue to adjudicate your application for interim work and travel authorization, and you get to stay here. So it's really, if you can get your foot in the door, it's a good thing. And you don't get your foot whacked off just because the room's too full, right?
Well, that's very good news, I think, for our investors, particularly those investors from Vietnam and India. So right now the door is open, I guess.
Well,
they're not going to whack off your foot. Okay, not yet, but
the door should be open as soon as the State Department revises the bulletin.
Soon. Hey, Jen, could I make a comment? I mean, and like Robert's comments on this, I mean, one of the things that, you know, we talked about protection for the investor, a very important part of this bill is the treatment of grandfathering. And, you know, there was concern, you know, when the bill lapsed in June, you know, what's going to happen to those people who have come in? You know, would the United States respect the fact that they invested prior to the program expiring? Would they be okay? That's been addressed, and going forward for investors, there's protection in the bill. And this was something that IIUSA pushed on really hard to make sure that grandfathering was included, and also age out, the way that's being handled. So, you know, we talk about this being a very investor friendly, very aggressive program to support the investors, which drive the industry. So could you comment on those two things? And I hope I'm not jumping some of your stuff there.
If you're asking me to?
Yes.
Bob? Yeah, I feel super strongly about this. And you know that, Bob, because you've seen some things that I've lobbed into the discussion with IIUSA. And IIUSA, I think, took the very high ground on this, and I'm very proud of that organization and you for leading it in this particular regard. But, thinking back on this, 10 years ago, when Senator Grassley was pushing amendments and language, the first bills came out explicitly saying that new changes would retroactively apply to previous investors, and they would get intentionally screwed. I mean, that's the way it was originally written. And, the industry, particularly IIUSA, said, no, that is not on the table. That nothing is going to happen if that's the plan. It has to not be retroactive. And the more time came on, we realized, wait a minute, the way we've been living is that if somebody files an I-526, they make an investment, risk their money, file an I-526, and the regional center law they invested under is going to expire, a year later, and they know that their I-526 may take longer than that to adjudicate, a visa number may take longer than that to be available. They've got to live through who knows how many congressional extensions of the law before they get to the end of the process and are and can immigrate. And what happens if that doesn't happen? And then in June of 2021, we found out what happens. You fall off a cliff. You're completely in limbo, waiting for something to happen, and it's totally unfair. And so I think that helped focus, the industry players' minds, and helped us focus the legislators on the reality that it's not American and it's not fair to encourage people to make an investment into this country to seek permanent residence and then rip the rug right out from under them after they've done that by letting a law expire. So this law says explicitly, if you make an investment and file your I-526 before September 30 of 2026, then even though the law about regional center stuff expires September 30, 2027, a year later, if you file by September 30, 2026, you are protected. The expiration of that law will not affect you. So now, really, Bob, in my mind and in the mind of any sensible investor, the law currently expires September 30, 2026, because we shouldn't be asking an investor to make an investment and file their papers after the date that protection would fall away. And we need to get the law renewed or get that provision updated to line up with the 2027 date before asking people to invest after September 30, 2026.
Thank you. And how about on the age out?
Well, I mean, the law already is quite generous to people on age outs in the sense that you, as long as you file your petition before the child turns 21, then you're going to be protected. The child's going to be protected unless there's a wait of a year or more after your approval to get a visa number. And that is not changed. So if somebody, particularly from China, makes an investment for a child who's 20 today, and they're the time they have to wait for a visa number may exceed the time they wait for an I-526 approval, they run a risk of a child aging out. But there are protections for investors who get a denial of some kind, and they can file again within a year of getting denied, and their child is protected as if there had been no break and so forth.
Good, thank you.
So I want to go back to grandfathering a little bit here. Robert, some have called you the father of grandfathering. I know that you helped AIIA draft some language that you're pretty proud of, the Foreign Investor Fairness and Protection Act. What's in this section that got added to the end because of some of the great efforts from you two gentlemen, and what's different about that from what you drafted?
I mean, the words may be a little different, but it's the same. The purpose and the effect is the same. That if you invest today, or if you invest in file all the way up to September 30, 2026, you don't need to worry that the law governing regional centers expiring 2027 will affect you. It won't. You'll still be eligible. You may still wait years to get a visa number, depending, especially if you're from China. But you won't fail to get one because of the expiration of a law.
So you get a visa and everybody gets adjudicated. We're not going to tell you how long or short that's going to take, but you do have some certainty that it's going to happen.
Yeah, you'll get a hearing, and if you qualify, you'll get a visa.
Okay, Bob, so one of the biggest things that came from this bill is there's a new investment amount. Investments in TEAs are $800,000, and then we're at 1.05 million for non-TEA areas. How did Congress come to these numbers, Bob? And how do you feel about these new amounts?
Well, as everyone knows, the regulations put in place a minimum investment amount of 900,000 and $1.8 million for non-TEA areas. And that was in effect for a period of time until the bill expired, and then the regulations were overturned. So there was a period of time there it went back to the 500, but it was a very short-lived period of time. 800,000, is a number I think that Congress recognized the minimum amount, 500,000, had not been adjusted since 1992. And if you just ran inflation numbers against 500, I think, there's some arguments with respect to our position at IIUSA was that until the program really began taking off, which was, late 90s, or actually early mid 2000s, that the inflation number shouldn't have been implied until a program was actually being utilized. And if you do that, then that would have put the number at 750, I believe was the number. So, 800's 100,000 less than 900. That's a good thing. And it was kind of an arbitrary decision. There's still some arguments with respect to what it should have been. We thought for a while it was going to end up at 700. IIUSA was pushing for that. The principals and that by the principals, I mean the senators that were involved in negotiating the final language settled on 800 and 1050. So, it is what it is. And I think actually the number definitely had to be adjusted. Even at 800,000, it's still very, very competitive with other country programs, less than many countries. And it's 100,000 less than what it would have been under the old regulations.
Yeah, I think that, in general, we would have all liked to see a slightly lower amount somewhere, in between 500 and 900. 900 is probably too high because at that rate, we didn't really have any applications. And at 500, we've got a big backlog. So we've got to kind of keep it in between those numbers. So I think you're right. Okay, let's see here. So Robert, when I first started processing cases, a decade ago, all of my investors were all adjudicated in 3 months. Now we're looking at the longest processing times that I've ever seen in my entire life. So this bill, it takes direct aim right at those processing times. You were the former acting director for USCIS. So what is this bill ordering the agency to do to lower processing times for us? Oh, you're on mute.
Sorry, this law tells the agency to charge as much as it takes to adjudicate the cases in what the law says is a reasonable time. So I can't remember honestly, I can't remember what they say. Maybe it's like 180 days for an I-526.
Yep, and that reduces to 120 days, so 4 months, if you are in a targeted employment area in a regional center.
Which is going to be almost everybody. So But look, let's don't fool ourselves. I mean, that's a target. That's what the Congress has told the agency to try to do. One, it's going to take them time to set that up because they're going to have to figure out how much it really will cost them to do it that fast. They have to go through a real hard analysis to get that figured out. And then they have to make a regulation to publish that and then get comments on it and then finalize it. And it's nobody's going to be happy with how long that takes to get to the point that the agency publishes a regulation that says, now we're charging the right amount of money to do it fast enough. And though, meanwhile, there will have been a whole bunch of people who filed using today's amount of money. And I can't say how that's going to affect, how long everybody takes, but I think Congress has made it clear, hey guys, this needs to be done, in a reasonable time. Please get on it. And I think the agency will understand they need to staff up. And I think right now they're staffed down. I think they moved some people around during this kind of period of hiatus, and they're going to have to bring them back from wherever they transferred them to and hire on some more. And that's never been a process that works as fast as any of us would have liked or could have imagined that we could have done. But there it is. But we have reason to hope now, more than just plain hope. We have some reason to hope that processing times will get better, but it's going to take some time.
Yeah, and Congress has at least, set forth something that, we're trying to improve processing times. We want those processing times to improve. And, you've been called to Senate hearings before, hearings in Congress. And, that at least gives them some teeth when we go to our congressmen and we say, hey, these processing times are still really way too long, for them to then call on those people to give some responses in Congress, right?
Yeah, I mean, I'm going to tell you that the agency will tell the people in Congress, we're taking as long as we need to make sure that the people we give these green cards to are not bad guys and are using legitimate funds. And that takes a lot of effort. We're not going to short circuit that effort. And sorry, but we're taking as long as we need to take. And I don't think there are many congressmen who are going to try to make a huge deal about that. But I do think they'll get the message. They'll try. They'll actually try with a sense of a goal and a target they're supposed to hit, which they've never had.
Well, if I could add to that, I mean, the prior administration, I mean, it's not a big secret, was somewhat anti-immigration, and we saw a significant slowdown in processing during that time. And Secretary Mayorkas, when he was director, processing times were pretty reasonable, and he was a big supporter of the program. So I think a couple things are going to happen. I agree it's going to take them time to figure out what their staffing requirements are, but the funding is available through the program to staff up. And I think the attitude toward immigration is quite different, which is good for us. The Secretary of Homeland Security, Alejandro Mayorkas, is very familiar with the program and supportive. And IIUSA's efforts now will have moved already from lobbying Congress to get this bill authorized to doing what we can do to push on processing times. And so we've already talked to a number of senators and House members about it, the importance of getting the program back operating on a more timely basis. And so I think we're going to see some improvement here this year that'll be good for the industry. So I'm optimistic about the program in that respect.
Oh, I'm really glad to hear that. Even if we get processing times back to what they were, as Bob described in the Mayorkas area, back to, maybe like about 4,000 a quarter. I mean, they've already done that before, and that was just a few years ago. So, I mean, I think if we can do that, we can get our processing times down in the next year or so here.
Do you know how many thousands are currently pending?
I think there's about 13. Is that right?
I honestly can't remember. I haven't checked lately.
Yeah, I would say I think it's about 13. So if they can get back to about 4,000 a quarter, you know, that's a little less than a year to process everything that's in the pipeline right now. So I mean, I think that seems doable. I think it seems doable. I mean, they don't even have to get down to the levels of, you know, 120 days per applicant. If they can even just get everybody down to a year, I think people would be pretty satisfied with that.
Yeah.
I agree.
Robert, another thing that can also help to reduce some of the wait times is this new exemplar process. So I know it's not entirely clear under the new law, but with this new, well, they're not calling it an exemplar process, but under this new process, does each case, do you think, still need to stand on its own? Or do you think that there'll be some efficiency and more deference that's been issued based on, you know, the projects having to file the projects in advance of the I-526 is getting filed?
So let's quickly, you know, for the uninitiated, kind of explain what you mean by exemplar and what that's all about.
Oh, yeah.
So I'm very aware of this because I kind of invented the exemplar process. I was arguing, I had come out of the agency, I was representing players. I was speaking on behalf of IIUSA at the time and saying, look, back then they would only adjudicate an investor's I-526. And so if they had questions about the project, then they would send a request for evidence or a notice of intent to deny to every one of the investors who were in that project. And all these investors are freaking out. What's all this about? How do I answer these questions? And then and it was a very inefficient process. And I was saying, look, there should be a way for a project to submit the papers about it and get an approval of that, because that's common to everybody who's going to invest in that thing. And why don't you just adjudicate that one time and just adjudicate all the investors about where their money comes from? So finally, they agreed. They said, well, we're going to limit it to cases that are sponsored by regional centers, and we'll let the regional center be the party that files the example of the project. And they use this term exemplar. And so regional centers had the option before to file all the documents about a project, all the offering documents that described everybody's relationship. We need loan agreements between the NCE and the JCE, all the stuff about the business plan that showed that it was credible, and file all that and let the agency review it. And then when the investors filed, they would reference that exemplar filing. Well, the new law takes that and kind of runs with it and says, okay, that's not optional anymore, that's required. So before any investor can file any papers about any petition, the regional center has to file a request about the project, which is like the exemplar we always talked about. So it's the same thing. There's a few specific requirements that are a little bit more detailed than what you had to do before, but not a huge thing. And luckily, the law says the investors don't have to wait until that thing gets approved. They can start filing their petitions as soon as that exemplar is filed. But they would refer to that exemplar filing, maybe with a case number that it gets. And this law says for the first time, they can refer to the documents about the project that are in that exemplar filing. And they don't have to kill 20 trees to include all of that in each one of the investors' individual I-526 petitions. Totally sensible. Now, my experience is, though, that even after a project has been come up with, things tend to change. And there are changes made to the agreements, changes made to the business plan. And there has, when you've locked in the original project in stone and the investors have filed referring to it, then there has to be a process to deal with what happens if there are any changes. So the exemplar would have to be amended with USCIS, and then each investor would have to file something to say, I agree with those changes that have been made, and I'm still with it. Something like that. But all of that I think is very well intended. You know, it would be nice if we could know how long it will take to get an exemplar approved. And I've always argued that it makes total sense to make for the agency to put the very most emphasis on expediting exemplars so that investors can have an approval in their hand before they make the decision to invest. In real life, so far, that has not been the case. And in most situations, you know, a compelling business deal can't wait for how long it takes USCIS to adjudicate an exemplar. And if you did that, the project might be done before any investor could invest if you had to wait for approval. So nobody, even investors, shouldn't want to have to wait until approval of an exemplar, and they don't have to. But with hope, we can keep pushing on USCIS to adjudicate those, and we'll have to remember, it was Ali Mayorkas, the current DHS secretary, who was the USCIS secretary, who put out a draft policy memo one time that said just what I said, that they would emphasize and expedite exemplar filings to get those done quickly. Made total sense. Maybe he'll prevail on them now that he's the boss's boss to get that done. We'll see.
Well, that would be absolutely great. And if not, hopefully we can put a campaign out there to get you to be the director again.
Yeah.
Been there, done that.
Yeah, I was going to suggest that.
Okay, switching topics here. Bob, integrity forms for investors have always been sort of a hallmark of your efforts. You know, what's your inspiration behind that, and what kinds of new protections can investors see in this bill to help them from making sure they don't get defrauded?
Yeah, I mean, to me, that was kind of the basis of everything from a foundation standpoint, critically important. The regional centers that have been operating for years successfully have pretty much been doing everything that's required by the law. I mean, good operators, you know, have a fund administrator. They make sure that everything is compliant, that the project is strong, nothing's misrepresented, you have a solid business plan, et cetera, et cetera. So the good operators have kind of gone beyond what was required in the old law to make sure that it's just well done from a business standpoint with audits and different things. So the new law codifies some of that, including bona fides for regional center operators. There's some restrictions there, which I think are really good to prevent vertical integration from overseas, which has happened in some cases. And you know exactly who the principals are of the regional center and those individuals that have any influence over the decisions with respect to investor funds. That's critically important. Some of the issues with the program in the past have been kind of a looseness in that area of the law. And I don't care if it's EB5 or it's insurance or banking or manufacturing, you know, there are people that will figure out how to take advantage of individuals that are unscrupulous, they're fraudulent, they're bad people. So the tighter the program is, the better it is for the community and ultimately the investor, which is most important. We have to protect the investor. We've always talked at the IIUSA conferences about a pyramid with respect to the industry. At the top of the pyramid is the most important person, the individual, is the investor. And if we don't do everything we can below that, including the regional centers, the developers, the construction companies, the legal contributors, the professionals like Robert, to make sure that we're protecting the investor, then we don't have a program long term. So that has been a hallmark of IIUSA and something that everybody in the industry who's operated properly, and I would say it's the majority of the industry, have been concerned with the investor first. but that's been really important to me personally and at First Pathway Partners. So I'm delighted with the the protection that's been built into this law. That's going to create a little more work for regional centers in some cases, some not, but it definitely will shore up the investor and make sure that some of the abuses that have happened, and on a percentage basis, it hasn't been a huge number of people that have done it, but it has involved a lot of money. So, people that have bad intentions are not going to get into this business going forward. That's my hope. That's my belief. That doesn't mean there won't be some challenges in the future, because dishonest people show up in every industry, but this will definitely eliminate a lot of the stuff that went on in the past. And I'm very, very excited about that. And that has been really critically important for IIUSA. And it's the reason we supported Grassley-Leahy. Now, if you think about, what happened to those two individuals from a historical standpoint, Senator Leahy was personally stabbed in the back, if you want to call it that, by a regional center in his home state that he supported for this program. There were some abuses, and if it had been most people, I wouldn't have blamed him from walking away from the program and saying, you know what, I don't want any more of this. But to his credit, he saw the value of the program nationally and what it actually did in his home state. And in spite of the abuse that happened there, he hung in there, and he and Senator Grassley have been subject matter experts and committed to reforming the program in a way that something like that would never happen again. So I give him and Senator Grassley a lot of credit for kind of staying the course. And we stayed the course with them because we believed in them, that they were doing the right thing. They were not trying to kill the program, which a lot of people talked about. They have been the biggest supporters and proponents of this program in Congress, and they won, and we won as an industry. So I feel really, really good about where we are and very excited about the program going forward.
Bob, I remember testifying in the Senate Judiciary Committee in about 2011 or 12, and Senator Grassley asked me, said, what's going to prevent the next, EB5 money scam like had happened back then in Missouri or something? And I said, well, the securities laws are there, and they are designed to punish bad behavior and help individuals who are aggrieved to address those wrongs. And otherwise, until the nature of man changes, there will be occasional fraud. I mean, that's the way people are. And but I think he decided right then and there, I'm going to see to it. I'm going to do some things that will reduce the ability of a fraudster to take advantage of this program, and he's done it. And the other thing that strikes me is that these integrity measures, in many respects, almost look like a further articulation of the IIUSA best practices document that IIUSA members have been called by each other to follow for a long time.
No, I agree, and your point's a really good one. And I just give those two gentlemen so much credit for hanging in there. And we're there. It's a pretty exciting time. So for investors, grandfathering is huge. There's so many good aspects of the program. There are going to be some things we have to sort through, but the base law is so far superior to what we had before, and it should give investors great confidence going forward. And I'm sure that a feeling of excitement and interest in the program will be rekindled quickly.
All right, we are getting a little bit close to the hour mark here. Robert, how much more time do we have before?
I'm here for you. Go ahead.
Okay, well then I will do some rapid fire Q&A from the chat box. So let's just try to keep these answers really short and just keep them rolling. All right. So when will USCIS get back to processing I-526? Do we need to wait 60 days after the president has signed the bill?
Well, the investors who have already filed should be receiving adjudication as USCIS gets to it. I've received 2 EB5 approvals yesterday and today.
That's great news.
Great. That's
From
good.
adjudications, well, they were adjudications that were issued last week. But they were cases that could be adjudicated this week too. I don't believe there's anything that prevents USCIS from adjudicating any petition, direct or regional center, that was filed before enactment. But what's clear is that nothing but a solo investor in a project could file today until 60 days from yesterday.
That's amazing. I'm very excited to hear that you've already had an approval come through. So it's good news for all of us.
Well, they weren't filed the day before that. Let's get that clear. You know, it was like 2 years before. But yeah, we did get approvals. Yeah.
One is better than the 0 that we've gotten over the past 8 months. Okay. Okay, another rapid fire question. Let's see. So people who are outside of the country, can they benefit from adjustment of status? That's going to be a no.
Well, I think what they're probably meaning is, can they come into the country and then apply? And I would say they can't just get a visitor visa and use that, misrepresent themselves as coming to Disney World, when in fact they're coming to, you know, file an adjustment application. That could end up backfiring on them, and they can be found to have made a misrepresentation that makes them permanently inadmissible. But if they truly, legitimately come here on a temporary purpose, like going to school or being on a work visa or something, then they can be here. And then if they have a 526 filed already, or whenever they're able later to file one, they could also apply for adjustment of status.
Yeah, that's great. Okay, so question about pooled directs. Do pooled directs exist anymore?
No, there is no such thing as a pooled direct case, meaning the way this law works, I think it's based on what Bob just said, that if anybody's going to pool investments, then they need to be subject to all of the rules and the oversight of a regional center that this law installs. And so they may be able to just do it just like a direct case might have otherwise done, but it's going to be under the sponsorship of a regional center who's watching, and they're going to have to follow the, you know, the fund administration and all that.
Okay, let's see. Has this bill been signed by the president? I think we already went over that.
Yesterday. Yesterday at a Rose Garden ceremony.
And we've seen some conflicting reports about this. I know that there were a couple of news organizations who over the weekend jumped the gun and said that President Biden had already signed, but that was not true. It was not signed until yesterday, I think like 2 o'clock.
I think there was a confusion because he previously signed a continuing resolution about the budget that was designed to give him until yesterday was designed to give the clerks time to get the papers all correctly set up so that he could sign yesterday.
Yeah,
yes.
And the confusion was understandable. He signed that Friday night, and when Congress negotiated the omnibus package, they added a 4-day period of time for him to finalize whatever details he had to. So the government was still funded through that 4-day period of time. So Friday night he signed the CR, which just extended 4 days, and there was confusion there, and I was one of the ones confused with that, but yeah, it's done.
Got it.
I'm also going to take one out of USCIS's playbook here, and I'm going to say no case-specific questions. I'm seeing a lot of people putting in their priority dates and all their information. Robert is also available as an attorney too as well, so you can also hire him to give you some personal advice on your case after this too as well. Let's see. Is filing a writ of mandamus a good option for someone who's been waiting a long time for their I-526 approval?
I mean, I don't think right now is a good time to do that, just because it was only yesterday that it became legally possible for the agency to adjudicate those cases. So let's give them a little time to digest what this means and get it going. I don't think a judge would necessarily appreciate a lawsuit filed right after this when the agency has been legally prohibited from adjudicating their case up to now. But, you know, in a few months, if your case is one of the oldest ones out there, then maybe it's a good, maybe I can't discourage you from filing a mandamus case.
So typically the EB5 category has about 10,000 visas. I think for this fiscal year, we have like 20,000 visas, all of which have not been able to be allocated because of the trickle down from the family categories. So, you know, how many of those visas, you know, do we think can be used between now and September 30th?
Wow. So it will depend on where the State Department draws the line on the, you know, the already approved petitions by people born in China. And, you know, those cases are all sitting, waiting to be set up for an interview. It also depends on the consular pipeline. I mean, the problem is that consulates have been closed down and understaffed and short-staffed because of COVID, and are not necessarily all fully up to speed. So it's entirely possible that all of those visas won't get used. But I think both USCIS and the State Department are trying to use all the visas that they can. There's been a very concerted effort inside of USCIS to approve as many cases as they can for people in other employment-based categories, EB2 and EB3, so that those visa numbers can be given out during the fiscal year that we're in. But I don't know. I don't know how many they'll be able to issue.
Yeah, and if I could add, so we had an officer's call yesterday. IIUSA is sending a letter to USCIS, to the director on Friday, just you know, imploring them to, you know, kind of get after it, because we don't want to lose those 20,000. We also have talked to Senate offices and House offices to also put some pressure, you know, express our concerns with respect to losing. You know, it'd be great if we could take advantage of all 20,000, especially you know, what we've gone through the last 8-9 months. So that's a big priority for us right now, to put whatever pressure we can on USCIS to take advantage of that 20,000 number, which will help everybody.
Right. I mean, the problem is they've got so many problems at USCIS, so many backlogs and so many product lines that they know they're not going to be able to please everybody. And it probably won't get to the full 20,000, but the more you can push them to get to as many as they can, then great. Yeah.
Squeaky wheel, right?
Yeah, maybe so.
Okay, how about I-924? Oh, well, this is actually more of like a kind of the exemplar that we talked about. So projects that already have some I-526s filed, do they also need to file this exemplar before clients can begin filing their I-526 if they've already put some in?
I believe that they will have to file a new exemplar that fits the new rules. They're different. There's more stuff that's required than was before. Time has passed. I'd be surprised if USCIS, you know, gives any credit to previous exemplars under the prior law. They might say you can amend your existing exemplar and show, I mean, if you can show that the project is just the same as when we approved it before, and then show also that you meet all the new requirements that didn't exist before, then we can more quickly review it and approve it than we might have been able to if you just filed out of the blue. But I'd kind of be surprised if they do that.
Sorry, I'm just scrolling through the questions here to see
But while you're looking, I would say, if I'm filing an exemplar, a new exemplar, I'm going to definitely mention that this was previously approved under the prior law. And here's the only thing that's changed, or the only two things that changed, or nothing's changed. And here's all the extra stuff that makes this eligible. So, maybe they can go back and short circuit the process a little bit.
Sorry, I got a lot of duplicate questions here. Hold on one second. So this question is do you think that adjustment of status will encourage more investors to file I-526 petitions?
Yes. I mean, I think that people, let's say somebody from India who otherwise faces a 30 to 50 year waiting period for a visa number in the EB2 or EB3 category. I mean, nobody knows how long that waiting list for a new person would be, but they know it's a long time. And if they know that they can file an I-526 and file immediately for concurrent process, and they don't have to keep trying to maintain an H-1B visa for years and years, that greatly, I think, meaningfully adds to the attraction of going ahead and pulling the trigger on an EB5 investment.
So there are some investors who, because of the pandemic, have obviously had issues with their projects. What does this particular bill do for protection of innocent investors whose projects have failed?
Interesting question. I'm certainly aware of a lot of those. Some of the industries that had used the EB5 program the most were some of the most affected by the pandemic. So this is a common situation. The law has a provision to protect innocent investors. As I read it, it only applies if there is a termination or debarment by USCIS of the regional center, the new commercial enterprise, or the job creating enterprise. I mean, it's a new idea that USCIS could terminate or debar an NCE or a JCE as opposed to just a regional center. But it's a great thing that, I mean, so I guess it's a kind of almost perverse that an investor who's affected by a situation like that might be hoping and even trying to somehow arrange for the termination of the entities they're associated with, so that then they can take advantage of the protections which allow them. Here's what it basically does. It says if your regional center gets terminated, then your NCE can go get sponsored by another regional center anywhere in the country. And if your NCE gets debarred or terminated, then you can, if you can salvage the money somehow from that and move it to another NCE, that can count, and you don't lose your place in the queue or anything. And if you lost your money, you can top it off and invest more to be able to create the jobs with a new NCE. But it depends on termination of the regional center, NCE, or JCE, and they're going to be failures of projects that may not result in a termination because it just was a business phenomenon that occurred. So that protection, the new kind of protection, might not help investors who just suffered a downturn in the industry that they invested in, unless somebody mishandled money or violated the rules some other way. It's also not totally clear that these protections will apply to pre-enactment investors. We'll have to see.
Robert, another one for you. What is a priority date and why is it important to get a good one?
A priority date is the place in the queue for visa numbers that is established by filing the I-526. So the way we divvy out the numbers and line people up in the queue for a visa number is you got in line when you filed your 526. So file your 526 early. That's how you get a good one.
Okay, can investors from China file in a rural project and then not be subject to retrogression?
That's a great question, and it is very meaningful. The law, as of yesterday, has a provision that sets aside or reserves 20% of the numbers. So if it's this year, you say it's 20,000 is the total numbers, then 4,000 of those numbers would be reserved for rural. I think that this, and then 10% is for high unemployment areas and 2% for infrastructure. I don't think that the 10% for high unemployment is going to be particularly meaningful because most EB5 investment is going to be in high unemployment TEAs. So there'll be a whole lot more than 10% who will be using that category, and it won't really have a meaningful effect. But for the rural, there might, without this reserve, there might not be 20% of the investors in a year who would choose a rural project. So this is real incentive to people to look at rural. And they may, somebody who is otherwise subject to a waiting list might be able to invest in a rural project and get one of those 4,000 visas, especially if there aren't 4,000 other people from other countries who step up. It's going to be, we'll have to wait and see how the State Department decides to allocate those 4,000. Will they apply the per country limit within that so that no more than 7% of those can be given to Chinese in any given calendar year or fiscal year? I don't know how they're going to do that. But, one option for somebody from China who wants to try to get on in here is to invest quickly in a rural project.
And then what about those folks who already have a pending petition for a rural project? Can they take advantage of those visas?
This is an open question. I don't think that's the way it's going to roll. I think that USCIS will say that we'll interpret this law to only apply to new investors, and here's why. The most important reason is a policy reason. Congress passed this law to incentivize conduct of investors to invest in rural areas. Well, why would they give away those numbers to people who already made the choice? That doesn't incentivize anybody. That just rewards previous behavior. But I think they're going to tend to say, from a policy perspective, this applies to new investors. From a practical point of view, it would be very difficult for USCIS to figure out who's a rural investor. They don't keep up with that regularly in a data-oriented way that I know of. They keep up with who invested in a TEA, but they don't know from the data whether that was rural or high unemployment. And they would have to open up every I-526 petition from the past to figure that out. Maybe they could allow investors to submit something to say, I'm a rural, so I should be getting that thing. And maybe that'll happen. I'll be surprised. I think that it will be interpreted to apply only to new filers, but that's subject to interpretation.
So here's a good one about concurrent adjustment of status and the allocation between those who are filing with the consulates and having an interview, and then also with the National Visa Center, I guess, first, and then heading to the consulate, and those who are adjusting status. How are the visas allocated between those two groups? Does concurrent adjustment of status mean that all of the people who are adjusting status are going to get visas first, and then all of those people who are waiting in country are going to have a longer wait?
No, USCIS doesn't allocate a visa number until they are approving an adjustment of status application. The State Department allocates visa numbers. They make a tentative allocation when they schedule an interview, so that they're not setting up an interview for which there won't be a visa number. And in the past, it has been quicker to get a visa number, to get an interview, a visa interview scheduled, than to get an adjustment application approved. So if you're trying to grab up a number before it's gone, you might even choose to use visa processing instead of adjustment of status. But if you want to get your foothold here and you're willing to potentially wait longer to get the end game of a visa, of a green card, in order to make sure you get to stay here in the meantime, then you might choose adjustment of status. And, you know, that's very broad brush. This is something that's very case specific, and you need to talk to your specific lawyer about this in the context of the specific country you're in and what's going on at the very time this comes up.
Okay, so what kinds of visas can file for an adjustment of status if they're here in the US?
Well, anybody who's eligible for a family-based or an employment-based green card for which there is a visa number might be able to apply for adjustment of status. Otherwise, you have to have a perfect lifetime immigration record. In addition to that, you have to have a perfect lifetime immigration record, or for an employment-based case, you need to have, you could have up to 180 days of violation or overstay since the time you last entered. But other than that, I mean, those are the main things. Well, I will say, I believe that in order to file for adjustment of status, you will need to have entered on a visa. This is super technical, but it could be complicated. Like if you entered on a visa waiver, you probably can't do this. Or if you entered last using advanced parole, you might not be able to do it. You'd have to go out and come back in using a visa. I believe that Section I-485C7 applies to EB5 investors as well.
And then we'll wrap up with the last question, which is going to be for each one of you, and it'll be a two-part question. And that is, what is your favorite thing in the law, the new law, for new investors? And what is your favorite thing that's in the law for existing investors? We'll start with Bob first, since Robert's obviously looking up frantically to see what the answer is. And
Yeah, I mean, I don't know if there's a favorite thing. I just am very excited about the integrity reforms that have been introduced. And I have to say the grandfathering aspect to protect the investors. So those were critically important. Robert was very involved in that. A lot of people were, but you know, IIUSA hung in there and supported it, and you know, we were able to get it done. So those are really, really critically important, because if the investor's not confident and excited about the program, has concerns, whatever they might be, you know, then the regional centers, the industry really doesn't exist. So fixing that, improving it, protecting the investor, both on the integrity aspects of the law, but also on the grandfathering. So they know if they believe in the United States and they want to come to the United States and they're going to invest their money and put it at risk, they have a place here and they don't have to worry about if the law changes, expires, whatever.
Yeah, so very much in line with what Bob said. I guess I would say for existing investors, definitely the fact that they're saved, and that they're saved and they don't, no new rules of eligibility apply to them. That's huge. For new investors, I would say, yes, all of these integrity things are great, but the protection, as I said from the very beginning, the protection from falling off a cliff in the future, like those we saw on June 30, that's huge. For new investors, they know I don't have to live through that junk. That's a great thing.
Jen, can I make one additional comment before we break here and thank Robert for taking the time to visit. I would encourage anybody that's interested in the program, involved in the program, to attend the Orlando IIUSA conference coming up in April. By then we'll have more clarity with respect to different aspects of the new law. We're going to spend the majority of the time talking about the different aspects of the law. It'll be a very informative session and very worthwhile for anybody that's involved in the industry. So hopefully we'll see. We already have a pretty good, very good sign up, and it's grown significantly just since the law was enacted. But it'll be a really good conference and opportunity to celebrate the success that we all have, and then help educate people, inform people with respect to the different aspects of the law.
Well, based on that, Bob, I'm coming.
That's great. Well, I can't wait to see you in person, finally.
You too, buddy. You too.
Yeah, I'm very excited to celebrate with both of you, and hopefully some of you that are watching this panel too can also attend as well, and we can celebrate with you in person too as well. Really looking forward to that. This session, the last question, this session is going to be available both on YouTube and then also to everyone after the session too as well. So you'll be able to rewatch it. I know we talked about a lot of very technical topics. So this way you can kind of rewatch it again. And if you didn't get something, as always, encourage you to hire a great immigration attorney to assist you with the process. There's a lot of things in this new law, so you want to make sure that you're going with the best immigration attorney that's out there to assist you through the process. And then just thank you to everyone who attended today, and feel free to also submit your questions to us too. We've got our contact information there as well, so feel free to contact us after with more questions that you might have.
Thank you, Jennifer. Great job.
Yeah, thank you, Jennifer.